Congratulations to each of you. Judge Meriwether, you've been nominated to the Court of Federal Claims, is that right?
Yes, Senator.
How many motions have you argued in the Court of Federal Claims?
I have argued hundreds of motions involving complex civil claims in numerous courts. The Court of Federal Claims is not one of those courts.
Okay, so the answer is 0.
That is correct, Senator.
Okay. How many cases have you tried in the Court of Federal Claims?
I have tried a civil case in the district court for the District of Columbia. Most of my cases have been resolved on motions. None of those cases have been in the Court of Federal Claims, although they involve similarly complex matters under civil laws.
So the answer is 0.
That is correct, Senator.
What is the tell me the grounds for granting a new trial in the Court of Federal Claims?
All of the trials in the Court of Federal Claims are bench trials, and the Court of Federal Claims, although it is not bound by the federal rules of civil procedure, its rules mirror those rules when applicable. So it's my understanding that the same rules that would apply in the district court are also applied in that context. But if I were presented with a motion for a new trial, should I be confirmed as a judge on the Court of Federal Claims, I would, of course, consult the rules of court of the Court of Federal Claims.
So what are the grounds for granting a new trial?
My understanding is that a new trial, you would have to comply with the applicable rules.
I know that, but what are they? What are the grounds? You said that the rules are identical to the Court of Federal Claims and Federal District Court. I'm not sure that's accurate, but just tell me what are the grounds for granting a new trial in the Court of Federal Claims?
Senator, that is not an issue I have had occasion to consider before, despite my extensive civil experience and my familiarity, not only with the federal rules of civil procedure, but I've also reviewed the rules of the Court of Federal Claims. But if I were presented...
I'm sorry. Go ahead. No, you go ahead. You go ahead. Were you through?
I did not mean to speak over you.
That's okay. You go ahead, and I want you to finish your answer.
So I would, if I were presented with that question, should I be confirmed, I would, again, consult the rules and follow the precedent.
Okay. All right. Let me be sure, Judge, I understand your testimony. Can you tell me one single ground for granting a new trial in either a federal district court or the Court of Federal Claims as we sit here today?
Yes, if you misapplied, if there were gross misapplication of the law, certainly a litigant would argue for
anything
a
else?
Trial.
There are like 6 or 7 of them. Can you tell me any others?
Trials are so infrequent in the civil context, and although I have presided over bench trials and a jury trial, I have not been presented with a motion to have a new trial.
Okay.
So I've not.
Okay. What's a contract of adhesion?
A contract.
Excuse me.
Senator, I'm familiar with contract law, the concept of contracts of adhesion.
Yeah, you're going to say a lot of that. That's what Court of Federal Claims does. What's a contract of adhesion?
Senator, the Court of Federal Claims does handle a lot of procurement cases. Those typically turn on interpretations.
Yes, ma'am, but I'm going to run out of time. What's a contract of adhesion? If you don't know, just tell me.
Senator, despite my extensive civil experience, including dozens of cases that include contract cases, I have not dealt with the question of what a contract of adhesion is, but should it be presented to me,
Sure.
I would.
You'll look it up. Okay. Do you remember a case, Judge, called United States v. Allen?
Yes, Senator.
You were reversed in that case, weren't you?
I made a pretrial detention decision for, I believe, 5 defendants. I believe that Mr. Allen was one of the defendants for whom the district judge disagreed.
Yes, ma'am. But you were reversed.
My pretrial detention ruling, I believe, was.
Do you remember a case called United States v. Johnson?
Johnson's, are you referring to the pretrial detention matter?
In this case, you had a defendant who was trying.
One of the defendants for whom the district judge disagreed.
Yes, ma'am. But you were reversed.
My pretrial detention ruling, I believe, was.
Do you remember a case called United States v. Johnson?
I have had multiple United States v. Johnsons. Are you referring to the pretrial detention matter?
In this case, you had a defendant who was charged with traveling with intent to engage in illegal sexual conduct with a kid. And the defendant also testified that he had, quote, had a sexual interest in minors and even had a sexual relationship with his daughter. You remember it now?
Yes, Senator.
Okay. And you were reversed in that case, weren't you?
I made a narrow decision in Johnston that he should be released for 21 days so that he could, and placed on home incarceration so that he could get cancer treatment that he had been unable to receive.
You wanted to let him go out for 21 days, is that correct?
I don't think that's an accurate characterization.
Well, that's what the district court judge said.
The district
court said, no way am I letting this guy out on the street for 21 days.
The district court judge concluded that his life was not at risk because he had had the medical appointment that he had not had when he appeared before me before the appeal. So under those new facts, the factual predicate for my temporary release decision no longer existed.
That's not the way I read it, Judge. Do you remember a case called United States v. Voucher and United States v. Patel? You were reversed in those cases, too, from trying to let somebody go, weren't you?
In those two cases, my flight risk assessment under the Bail Reform Act, I believe, was reversed by the district judge.
Okay. I'm out of time. Thanks, Mr. Chairman, for your indulgence.
Judge Merriweather, let me just ask you in my short remaining time here. I think Senator Kennedy was asking you about this case, United States versus Johnson, where you recommended the release of a sexual predator to get medical treatment. Is that right? Do I have the right case?
Senator, I recommended a 21-day, a temporary release for medical treatment after holding multiple hearings and giving the government multiple opportunities to get Mr. Johnston to his appointments, because as I noted in the opinion, I thought the charges were deeply disturbing. I take very seriously the danger to the community, and I found when I balanced the four factors that I had to consider under the Bail Reform Act, that it was only his history and characteristics, which was that at the time that issue was before me, he had an urgent need for diagnostic and treatment, cancer treatment,
Let me just say, I'm sorry to interrupt you. I'm almost out of time. I just want to make sure I understand the sequence, because I might, as to my questions on Judge Basis, I might not have the sequencing right. So just, you can correct me here. So I thought the government filed an emergency appeal of your release order, and you were overturned by the D.C. district judge because, for among other reasons, the predator here had been caught in a sting operation. He'd admitted to sexually abusing his 8-year-old daughter. He had been previously court-martialed for molesting a child when he was in the Air Force. That child was his adopted daughter, and he claimed to have sexually molested other children, and the government thought that releasing him was a terrible idea. The district court agreed with him. Agreed with the government. So I just wonder, in light of all of that, as you look back on it now, do you think it was a bad decision to recommend release for him?
Two things. First, all of the abuse that it was alleged was horrific. The charges that were in front of me did not involve the molestation of his daughter, which I believe had happened 15 years earlier. And my decision was not based solely on the nature of the charges. That's but one of four factors that the Bail Reform Act required me to consider. The factual predicate, as I highlighted in that opinion, I found it very challenging to even entertain the idea of releasing someone charged with such heinous crimes, as well as someone who had a history decades earlier of abuse. But I found that his own interest in self-preservation paired with stringent conditions, being under the custody of his wife for a limited period of time and only allowed to leave his home to go to the doctor in order to get the timely cancer treatment that he needed, that despite 3 opportunities he was unable to get through no intent, malicious intent of the government.
Can I just ask, this is it, Mr. Chairman, this is my last question. Can I just ask, I thought that he was getting cancer treatment, but your judgment was he wasn't getting enough or the right kind, but he was getting treatment. Is that not accurate?
No, that was the change between my ruling and the time of the reversal. I gave the government 3 opportunities to take him to the doctor.
Was he wasn't getting enough or the right kind?
The change between my ruling and the change between my ruling and the time of the reversal. I gave the government 3 opportunities to take him to the doctor, and I kept him detained despite it. He did not get to the doctor. I ordered him temporarily released so that he could see a cancer specialist, because cancer is a time-sensitive issue, as many of us know, with loved ones who are survivors of cancer. And then the next day, he got to the doctor. Had he been to the doctor, I would not have released him for 21 days. I didn't feel that he needed a specific doctor, which was the facts that were presented to the district judge. It was that he see any doctor so that he could timely have his cancer addressed. Unfortunately, that did not happen before he saw me, so I made the very difficult decision of ordering